Justice of the Appellate Division, 4th Department. Hear ye, hear ye. All persons having business before this court will draw near to their attendance, and they shall be heard.
Calling the first case this morning for oral argument is People versus John Brady. Okay, both of you have to unmute yourselves. Mr. Schifrin, you're muted. You're muted.
Is this
There
better
you
now?
are. Thanks.
Thank you, Your Honor.
Go ahead.
Good morning, and may it please the court. The prosecutor's case that this was a robbery by the Brady brothers of Mr. Wang, not simply a fight between the Bradys and Wang, is based entirely on the testimony of Mr. Wang. The Wang is not a credible witness. His testimony that he worked for a Mr. Lee, who he claimed he never met.
But Mr. Schifrin, isn't credibility for the jury?
Initially, but of course this court has weight of evidence jurisdiction.
Certainly, and there were other witnesses.
There were no other witnesses to the robbery, and that's critical. The two other witnesses
Fighting, so you're saying they weren't witness to what was taken, if anything at all?
Exactly. If I can go through what they testified to and what the evidence was. The three things that were claimed to have been stolen were a certified check in excess of $100,000, for which there was no proof that such a check was ever issued by any bank. No proof from the bank, no proof from the business, no proof from the duplicate receipts from the certified check.
Mr. Schifrin, I'm having a little trouble hearing you. If you could just speak up a little bit, please.
Is this better, Your Honor?
Yes, thank you.
Sorry about that. So first of all, there's no proof there was ever a certified check. It could have been easily proved by either a bank, by the business, or by duplicate copies of the check. There was no proof of cash. There was no proof.
Is there a requirement that the things that were taken be recovered and presented at trial?
No, no, Your Honor. But let's go back to two things. Going back to your prior question about the witnesses, Mr. Marsh, the prosecution witness, testified that he saw one of the Bradys holding the messenger bag before entering the car and before having the fight. That's inconsistent with the claim that the bag belonged to Mr. Wang. It's consistent with it being a bag owned by one of the Bradys. The other eyewitness, Mr. Shields, didn't notice anything until the fight began. So again, you're dependent totally on the testimony of Mr. Wang, and his testimony is simply not believable because he lied about not knowing that this was not a licensed auto broker. There's no proof there was ever a bag. There's no proof of a certified check, and there's no proof of cash.
I think we have that argument. We'll have to look at that very carefully.
Thank you, Your Honor.
It's great.
Good morning, Your Honors. Lisa Gray for the People. Simply, this verdict was not against the weight of the evidence. As Your Honors have pointed out, there does not need to be proof that they don't need to find the money or the property that was taken. The jury was free to draw those logical inferences based on the corroborated evidence that was presented. Wong, despite any sort of unorthodox way that he and his employer decided to purchase these luxury vehicles, certainly was corroborated by the eyewitness testimony, forensic evidence.
Are you referring to evidence from his DNA holding onto the car, etc.?
Yes, and also corroborating Wong's version of events. Wong's blood was found on the co-defendant's car. That certainly corroborated what Wong explained happened. And also, I would certainly remind this court that the co-defendant's case rested primarily almost on identical evidence. In this case, he was convicted of the exact same crimes as Mr. John Brady, and this court—
The same exact evidence. They were tried together.
They were tried together. I think the only difference in the evidence was there were some cell phone records that pertained only to Bashan Brady that were not considered by the jury with respect to John Brady. I think that was the only difference. But certainly this court found in Bashan Brady's case that the verdict was not against the weight of the evidence. And there was nothing so inherently incontradictory or just unbelievable about Wong's testimony or even the eyewitness's testimony that would render this verdict the weight of the evidence. So for those reasons, Your Honor, I would ask that this court, like in Sean Brady's case, affirm the conviction in the indictment.
Thank you both.
Thank you.
And the next case is the People versus Christopher Tucker. Morning.
Good morning, Your Honors, and may it please the court. I'd like to address the first 2 points in our brief this morning, starting with the first point. The lower court here erred in denying defense counsel's request to incorporate the bill of particulars into jury instruction. Under the specific circumstances of this case,
Just like, I'm having trouble understanding what you're saying. Can you move a little bit closer to the microphone? Thank you.
Sure, is that any better, Judge?
Yes.
Okay, I apologize. Under the circumstances of this case, that error requires reversal because the defense was prejudiced. And specifically, the defense relied on the dates set forth in the bill of particulars to mount a defense against the charge and to show that at least one of the acts could not have occurred during August 2016.
Wait a minute, did the bill of particulars in any way limit the allegations to any of the specific acts? It didn't, correct?
Your Honor, the bill of particulars did list 6 specific acts with time period associated with those acts. 2 of the acts were irrelevant at the time of trial because they occurred in Oswego County. And so in this case, defense counsel specifically relied on the prosecutor's assertion or representation that the August 2016 act, or the 4th act, occurred during that specific month, and mounted a defense, presented evidence to show that the complainant was never at the Tucker household during August, and therefore that act could not have occurred.
Right, counsel, I understand what you're saying. But your contention, if I understand you correctly, is that the court should have read the bill of particulars to the jury, should have included the bill of particulars to the jury in its instructions. Is there any cases that say that that has to happen? If the people specify in the bill certain dates, certain acts, is there any case that says in the charge, if the defendant asks for it, the court has to include those dates and acts in the charge?
I think so, Judge. In our
Which case?
We cite matter of Corbin v. Hillary, as well as people.
Yeah, I just read that about 10 minutes ago. Where in there do you see that? Did that happen in that case? Did the Court of Appeals say you have to charge the jury? The people in that case had to charge the jury with the bill of particulars?
I think it's at minimum it's implied, Judge, because the court said that the people's proof, they're essentially bound by the bill.
Correct. It says that they're bound by it, and I don't know if there's any disagreement on that, but is there any case where an appellate court said a trial court had to read the bill of particulars in a particular count to a jury? Because that didn't happen in that case, in the Corbin case.
Well, Judge, in People v. Williams, which we cite in our reply brief, the indictment, or in the bill of particulars, specified certain acts that had to be proven. And in that case, this court said that because the jury instructions allowed the jury to find Mr. Williams guilty on a broader set of acts, a number of different felonies rather than the specific felony specified in the bill of particulars, that constituted error.
Right. No, I agree, because I think what you're really trying to say here is that the evidence rendered the indictment as amplified by the bill of particulars. It limit the people, so evidence that came outside the bill, maybe the jury convicted them on uncharged evidence. Isn't that what you're saying?
It is, but I think more fundamentally, Your Honor, it's a question of fair notice of the charges against.
Well, let me ask you this, Counselor. The bill of particulars, doesn't it read included but not limited to those particular acts? What effect does that have on your argument?
Judge, I think that language is effectively surplusage, because if the prosecutor could say that, well, these are some of the things that we're going to prove, but we're not limited to this, that would negate the purpose of a bill of particulars, which is to give specific notice to the defendant and allow him to craft a defense. If the prosecutor could then prove whatever he wants at the jury trial, then
or you could complain about it that it's not particular enough.
Correct.
Well, the problem here, though, Judge, was that it was particular enough, but that the prosecutor was not held to those particulars at trial. And, I acknowledge that the case law does permit variances as far as the time set forth in the indictment is concerned. However, that is only when there is no prejudice to the defense. And in this case, I think the record makes clear that defense counsel did rely on this assertion in the bill of particulars to craft his defense and to try to show that this August 2016 incident could not have occurred at that time.
Okay, I think we have that argument. Do you have any other arguments?
Sure, Your Honor. I'd like to address point 2 as well. And we acknowledge that the prosecutor—
Is it preserved?
It's not preserved, Judge. However, I think the combination of both the repeated nature of the prosecutor's improper comments as well as the severity of the comments themselves do warrant this court's review in the interest of justice. And I would respectfully submit that the level of impropriety here is commensurate with other cases where this court has reached the issue in the interest of justice. And I would also note that I think the majority of the cases this court has reversed on prosecutorial misconduct grounds have been reached in the interest of justice. And while we list several instances of improper comments in our brief, I won't go through them all. However, I just wanted to 2 of those, starting with the prosecutor's comments on Mr. Tucker's right to silence during the government-initiated phone call and the police interrogation. The respondent's brief suggests that because Mr. Tucker spoke at all during those 2 instances, the people were permitted to introduce evidence of his failure to speak. I think that argument very much overstates the exception found in People v. Savage, which involved a narrow circumstance where the defendant provided the essential facts of his involvement, but left out one exculpatory detail that he presented at trial. Here, Mr. Tucker all along denied the allegations and never made any admissions. And the prosecutor's comments to the jury asking it to draw an inference of guilt based on his silence was particularly prejudicial here, because it's not a case where there was overwhelming evidence. We had the credibility of the complainant, the controlled call, and the police interrogation, and the comments relating to the right to silence influenced and perhaps tainted the jury's consideration of those latter 2 pieces of evidence.
Okay, I think we understand that, and we'll look at that. Do you have anything further?
Sure. The last thing I wanted to highlight is the prosecutor's exaggeration or mischaracterization of the evidence. The testimony here was that Mr. Tucker put his penis on the complainant's mouth. The prosecutor, on summation, turned that into Mr. Tucker put his penis down the complainant's throat, which I think is an exaggeration of the evidence really meant to inflame the jury and view Mr. Tucker with disgust, and then coupled with the denigration of the defense.
And again, of course, this was unpreserved, correct?
I agree, Your Honor, but given, again, the volume.
But can I ask you something? They're unpreserved, and these could have been, some of these errors could have been cured had there been an objection. There could have been a curative instruction.
That's true, Judge. We make an argument that defense counsel was ineffective for failing to object, and I think under People v. Fisher, we have a similar amount of misconduct. In this case, defense counsel did object to one of the comments I mentioned about Mr. Tucker putting his penis down the complainant's throat. That objection was specifically overruled, and I think it legitimized that comment in the face with respect to the jury. And so I think under the totality of the circumstances, the comments here weren't reversed. Thank you.
Okay. Anything? Are you you have anything else?
No, no, Judge, that's all. Thank you.
Thank you.
Good morning, Your Honors. Brad Osler for the people. May it please the court. I think I would agree with, I think what the panel was suggesting with respect to the defendant's first point. Even if the court had read the bill of particulars, even if it was for some reason obligated to, which we would submit it as not, the people's evidence was limited to exactly what was in the indictment as amplified by the bill of particulars. So the failure to read it in no way prejudiced the defendant, and it didn't.
So are you saying that your theory did not change?
That's exactly correct. I think the most informative comparative cases are those ones where you see a theory of prosecution where the defendant, say, had to use physical force versus threats of force, and the jury instruction suggested that either would be appropriate, whereas the indictment and or the bill of particulars only identified one. We don't have that here. The indictment and the bill of particulars are consistent with the people's evidence at trial. There's no alternative theory. There's no way that the jury could have convicted on some alternate theory. There just wasn't evidence presented to suggest that.
Yeah, counsel, I'm more concerned about the defendant's right to silence. The prosecutor's summation, where he comments on what he should have said and should have asked and so forth. What do you, it's not preserved, but somebody objecting at that point is just calling is drawing focus on it. Again, what do you defend the propriety of those comments?
To a certain extent. Let me first note that the prosecutor's comments were not, with respect to the controlled call and his statements to police after he waived his right to silence. The prosecutor did comment on the fact that the defendant's body language, his heavy breathing, I believe it was mentioned. There's certain things that the jury could obviously observe that speak directly to the defendant's credibility in making those statements, and those certainly are permissible. With respect to the comments about the silence or the defendant's somewhat evasive responses to the police interrogation or to the controlled call, I think, first of all, the defendant waiving his Miranda rights when he spoke to the police opens him to a certain level of comment by the people when we present that evidence.
So do you perhaps it's not enough to reverse the case, but do you condone what was done here?
I think in light of the Court of Appeals cases that speak to this, I would have to acknowledge that it was probably a bit of an overstep in terms of comment on the evidence.
But wasn't it an overstep too, or overstatement of the facts, the comments about the throat, many comments about the throat? There's no evidence about contact with the throat. It just seemed to be overreaching and trying to prejudice the jury against this defendant.
I do agree that that particular characterization of the evidence was incorrect and was in language that was perhaps intended to inflame the jury or meant to appeal to the emotional side of the case.
Right. So what do we do in this situation where we have some questionable conduct, improper conduct, as you acknowledge, frankly, in a summation? Do we just say unpreserved, call it a day? Do we say don't do it again? Bad prosecutor, please don't do it again. What do we? At some point, we have to start reversing on these things, do we not?
Well, I would submit that the analysis of the alleged misconduct here by the prosecutor can be looked at in sort of with respect to the standard that's been well established here. Did it sidetrack the jury? And I don't think we could say in this particular case that it did. I certainly would acknowledge the comments that were inappropriate. However, when comparing them to the comments made, essentially within seconds on either side during the summation by the prosecutor, there were correct characterizations of the evidence, certainly things that were permissible, and we would be remiss if we had not commented upon them in summation. When considering everything and when considering the totality of the summation, I don't think we see this case rising to the point where the jury is sidetracked. Again, the bulk of the prosecutor's comments were, I would submit, were correct characterizations of the evidence. And it's hard to imagine that the jury, in hearing these limited instances of an incorrect characterization, somehow forgot the lengthy and apparently credible testimony of the child victim. I don't think I think it sets a somewhat dangerous precedent where if a prosecutor makes one comment or two comments in close succession here that are questionable, if that's enough to overturn a case, it's
Right.
start to.
But then you understand the problem on the other side is that there are improper statements, not just questionable, but improper statements. The judgment gets affirmed on appeal for various reasons, unpreserved, overall weren't so unfair as to deprive the defendant of a fair trial. And then they just continue. I mean, I remember when I was in your position arguing these cases, and the judge would yell at me, "Go back and tell the prosecutors not to do it again." Then we get affirmed, and here we are 25 years later, and prosecutors still doing the same things over and over again. And unless we reverse, it's just going to keep continuing, case after case.
I certainly understand the point that you are suggesting, Your Honor, and I don't have a good response for it to suggest that repeatedly turning a blind eye to prosecutorial misconduct is a correct answer or a permissible one. But I think in this particular instance, in light of the bulk of the prosecutor's statements on summation, again, it doesn't rise to the level that the jury was sidetracked in making its determinations of fact. And I say that, comparing the case to many others of this nature, unfortunately, where there were, additional facts, additional statements, or probably more importantly, more pervasive statements. And the comments here were, if we want to really whittle it down, there were 3 comments sort of in close succession mischaracterizing the evidence. And that's, in light of a days-long trial, it's hard for me to really believe that in a reasonable fashion that the jury was sidetracked.
Do you have anything further?
Your Honor, unless there's any other questions, I'll rest on my brief.
Thank you both. People versus Robert Collins. Ms. Wild, can you unmute? Thank you very much.
Yes, good morning, Your Honor.
Go ahead.
So a review of the record really should leave this court with reasonable doubts that Mr. Collins engaged in any sexual misconduct towards his great-granddaughters, let alone when, where, and with the frequency that they alleged. A weight of the evidence review really just reveals that the people did not meet their burden of proof in this case, and this court should reverse. I was here for earlier oral arguments, and obviously the court brought up the fact that the jury is preliminarily charged with making credibility determinations, but the Court of Appeals and Della Moda emphasized this court's role as a second jury, and that in the appropriate cases should substitute its own credibility determinations. And this really is the appropriate case for that. Their testimonies just didn't square with the testimony of other witnesses, and there were a number of other witnesses in this case. And much of their testimony, especially relating to the frequency of the conduct, defies common sense and was also contrary to the people's expert testimony that abuse is rarely 24/7, and that there are long periods of time in between abuse because of, lack of privacy and opportunity. And so their testimony that, they were touched 1, 2, 3 times a day, every day that they were at their great-grandparents' home, just it's not a credible testimony, and there are certainly other issues. We lay out our argument pretty thoroughly in our brief, but I just wanted to take a moment to emphasize that this court can substitute.
We're aware of that, of course.
It should.
We're totally aware that we can't substitute. The question is, should we in this particular case? And are you saying that the testimony was so fraught with inconsistencies that there's nothing that the children testified to that was sufficient?
Well, we didn't raise a legal sufficiency argument. We only raised weight of the evidence. And what we're arguing is that it's clear from a review of even the paper record that the jury did not properly weigh the relative probative force.
Right. So you're saying if we then reviewed it, we would find that you are correct and that the verdict should be thrown out.
Yes, Your Honor.
Thank you.
Good morning, Your Honors. Lisa Gray for the people. I would just hold otherwise, that in this case, the verdict certainly was not against the weight of the evidence. If this court chose to review that, it would agree with the jury's determination. These were young victims that testified. They were even younger when the abuse was to have occurred. Any inconsistencies with respect to the timing of the abuse or the age when it happened was certainly thoroughly cross-examined. Mr. Collins called a total of 5 witnesses on his behalf, and the jury was certainly free to accept or reject the people's witnesses or the defense witnesses. And I think the verdict in this case certainly shows that the jury afforded the evidence the weight it deserved. I believe it was count 2 that the jury acquitted Mr. Collins on. So I think the verdict itself illustrates the fact that the jury.
Yeah, this case was unusual. I don't think I've ever seen a defendant of this age, over 80, allegedly sexually abused great-granddaughters. That's a first. We've seen granddaughters, but great-granddaughters, but did not the defendant acknowledge that he had been alone with the children under blankets in the exact spot where they claimed that it took place?
Certainly, defendant's own statements corroborated what the victims were saying. He admitted to the officer that there were many times he sat on the couch in the lower level of the split-level home, and he sat underneath the blankets with his great-granddaughters watching movies, which is exactly how the victims in this case described the abuse. So the verdict is not against the weight of the evidence. The verdict clearly indicates that. And for those reasons, Your Honor, I would ask that the court affirm the convictions. Thank you.
Both. People versus Michael Ross.
I hope the members of the court can hear me at this point. I apologize for any technology issue.
Pardon me?
I hope the members of the court can hear me at this point.
Okay, just a minute. We still have to wait for the other attorney.
I apologize.
Okay, there we go.
May it please the court? Sorry. Good morning, Your Honors. I hope that you all can hear me.
Yes, we can.
Okay. The people argue that my client's claims are barred by CPL 440.10 sub 2C. I'd like to address that first. There are 2 difficulties with that contention. The first is jurisdictional. The second is merits related. With respect to the 3 ineffective assistance issues, specifically that are raised in point 1 of my brief, those 3 claims were none of them denied on that ground. So pursuant to the LaFontaine rule, that contention would not be reviewable even if it were meritorious. As it happens, the contention does not have merit because every single one of the claims that I'm referring to here relied on information that was not part of the original record that was contributed by the 44010 record. Unless the court has any further questions about that, I would just move on to the substance of those claims themselves.
Go ahead.
To the extent that the court said that there was a lack of corroboration, that was partly incorrect. The affidavits of Morris and Henry were clearly corroborated that the attorney did not speak to them, and clearly corroborated that their account was such that this was something that would have needed investigation. And the statement that my client gave, which was litigated at a pretrial hearing almost exactly 3 months before the trial, even if we assume my client had not told counsel about them, which he says he did in any event, that would have put counsel on notice he really had to go investigate, talk to the people who were living there. To the extent, however, that it was not corroborated, this is not really the sort of case in which it would be appropriate to have denied summarily on that basis, because in the first place, even if we disregard the case law that Mr. Ross cited, that certainly at least gave him reason to believe that it was not necessary for him to have the affidavit from the attorney in the motion papers himself. And even if we disregard that the statutory language of CPL 440.30 doesn't contain anything saying lack of corroboration in and of itself makes the motion deficient, there's also the fact that Mr. Ross provided the functional equivalent of an explanation for the lack of inclusion of the attorney's affidavit by specifically requesting, not only by serving a copy of the motion on former counsel, and by specifically requesting that the court order that the attorney be made to respond if he didn't respond on his own. So this is not one of those kinds of cases, of which there are many, where the defendant seems to be trying to get the court to decide the merit of the claim behind counsel's back without getting counsel's input. This is a case where the defendant was saying, I want his input in the case. He's not trying to shut the attorney up.
Right, well, we've said many times, have we not, that the defendant seeking a hearing on a 440 motion doesn't need an affidavit from the trial counsel.
That's right.
Now, it may be at the hearing, the defendant has the burden of proof at the hearing, if you get that far. It might be necessary to have the testimony of the defense lawyer then, but we're not at that stage yet. And you say you met the threshold to warrant that hearing.
Yes, Your Honor. And I did cite some of that case law in the briefing, and I do appreciate Your Honor reminding me of it. With regard to the principal claim, which was the claim related to Mrs. Henry and Morris, one of the considerations that the court cited was defense counsel may have decided not to call them in order not to suborn perjury. There was an ethical obligation. If defense attorneys had to be this meek in saying, well, if I call them, it's going to be suborning perjury, its criminal defense practice would not look anything like it currently does or ever should. There isn't any ethical problem. I'm sorry, Your Honor? Oh, I'm sorry. I thought I heard a question being asked. There wasn't any ethical problem with calling them to contradict the prosecution's evidence on this. I would add, by the way, that 3 of the cartridge casings were found a significant distance away from where the shooting was supposed to be taking place, more than halfway up the driveway. That's just one of the considerations that made it permissible to conclude that this testimony would not necessarily have been perjured. Another point the court made was that calling them would have contradicted the defense's theory about operability and possession. That's kind of circular reasoning, because it presupposes the reasonableness of counsel's choice in that theory in the first place over the theory that would have been supportable with Henry and Morris. But even if we put that aside, number one, counsel's theory had no chance of succeeding on its own terms. My client admitted firing the gun. Operability and possession were not an issue.
Right, the only issue here, the only issue at trial here was whether your client fired in the air just to scare him or warn him, or fired at the victim. Am I correct? That's the only factual issue the jury was really called upon. Everything else was undisputed.
No, Your
Should have been
Honor.
undisputed.
The defense disputed that he possessed the gun at all, which was a ridiculous issue.
Well, your client admitted it to the police that he ran back, got the shotgun, fired it in the air.
That's right, Your Honor, which is why it was such an
So again, that's the only issue, is whether he shot in the air or if he shot at someone. And all you're asking for is for it to go back on this motion and have a hearing in front of the judge, correct?
Yes, Your Honor, that's correct.
Okay, thank you.
Thank you, Your Honors.
Good morning, Your Honors. May it please the court, Mindy Van Leuven for the people. Your Honor, these issues are procedurally barred, at least 2 of the 3. The lower court did address that in their order by stating that at least the issue with regards to the objections regarding ineffective assistance of counsel, as well as the petition for reassignment of counsel, and basically everything but the family member's claim was procedurally barred. That's addressed in the order on page 7 with regards to that being procedurally barred. With regards to the merits, everything else would be barred on the merits. The lower court did not abuse its discretion in denying the defendant a hearing on these matters. First of all, the defendant's claims are based upon 2 family members who allegedly came forward. These affidavits are from at least a year after or more in the trial. This litigation went on for over a year or thereabouts, and the defendant had 3 different counsels, and it wasn't on the record that he could have brought it up. So that may not be procedurally barred for that reason. However, that is a reason for that lower court judge to deny a hearing on this matter. One of the reasons, as Your Honors are well aware of, denying a hearing is that these claims are patently, you can just dismiss them out of hand. They don't have any factual issues to discuss.
And how can we say that these are patently ridiculous claims? Now, I'm highly skeptical of them, okay? I agree with you. I doubt very seriously that these witnesses were available to testify to these facts, even assuming these facts are true, but don't we need a hearing to resolve whether these witnesses are telling the truth, whether the defense lawyer knew about these witnesses, and if so, why he didn't call them? Don't we need a hearing to determine those issues? You may win at the hearing, probably will, but it seems premature to summarily deny a hearing on the ground that, well, the defense lawyer probably did not want to suborn perjury.
Your Honor, Justice Lindley, I completely agree with you. However, I believe that the lower court had good reasoning for denying this summarily. Number 1, the physical evidence, not even testimonial evidence, directly contradicted these statements. There were 2 other witnesses who, while they were, I believe, family members of the victim, did testify that the defendant shot directly at the victim. The victim's also physical evidence. They had a photo of where he had a welt, where he was allegedly shot. So the physical evidence alone, not sustaining any other testimonial evidence, directly contradicted these claims. That's number 1. Number 2 is these are the defendant's family members, so the credibility of them would be an issue to begin with. I think that out of hand, the lower court did not abuse its discretion or summarily denying those claims due to the physical evidence alone, not even outstanding any ethical obligations.
Okay, we understand that. We'll look at this very carefully.
Thank you, Your Honor.
Thank you. In the matter of Crystal Wingo versus Roman Thomas. There you are. Okay, go ahead, Mr. Greenberg.
Yeah, thank you, Your Honor. I'm representing Crystal Wingo in her custody matter, her custody action to obtain custody of his minor child, Kiara. My understanding from my last conversation with Crystal is that she now has de facto custody, or she had de facto custody at the time I spoke to her in January because Kiara has moved down to North Carolina and is now residing with her permanently. Now, if that is still the case, then I think that her current legal, what I advised her in January, and if that's still the case in April, then her current remedy in the courts in North Carolina for formal custody of the child. So with that in mind, with that change, since the current order went into effect, I would now argue that the current order is largely academic. I mean, unless you would disagree, or unless Ms. Talmadge would disagree, then I was rest on that point.
But don't we review based upon what happened before and why the court made its decision? Couldn't custody just easily change back to where it was, even if we accept that the children or the child is in North Carolina now?
I mean, it could. I mean, I'm assuming that there's been no subsequent order. Well, there has been no subsequent order as far as I know in Erie County, but what she's done down in North Carolina, she has not told me. So
the other order is still valid?
The current order is still valid, but even if you were to send it back to Erie County on a theory that there has been a change of circumstances, which is why the way we would agree with is that, you know, for the reasons I outlined in my brief, the breakdown of communication between Roman and Crystal, about how she found out about the court would be another example of that. If we were to send it back to Erie County, does Erie County still have jurisdiction over the child, given that the child could very well be in North Carolina? So.
Okay, thank you.
You're welcome.
Go ahead.
May it please the court, Your Honors, the child does still continue to reside with Ms. Wingo and has resided with Ms. Wingo since December of 2020 upon the father's consent. And so I do believe that the briefs before the court do provide a question for Your Honors to consider as to whether or not Ms. Wingo did at the time of the initial application testify to and provide to the court enough evidence to warrant a finding of a change in circumstance for the court to have taken it to the next prong to determine whether or not a modification in custody and access providing for the relocation would have been in the best interest of the child. And
are there any pending petitions right now?
No, Your Honor.
Any written agreements between the parties?
No, Your Honor. Not that I'm aware of. Nothing that's been filed that I've been assigned on.
Well, there could be something down in North Carolina, right?
That is correct.
If so, and there's an order down there transferring custody to the mother, this appeal would be moot?
Correct. I'm not aware of anything having been filed. I guess I wouldn't be a party to that. Although I don't believe the child has been there quite 6 months yet for them to have jurisdiction, but I guess if it were not challenged, then perhaps they could have filed an agreement.
But the bottom line is the father agrees the mother should have custody in North Carolina. The mother wants custody in North Carolina. There's nothing left to fight over, but we still have this order which gives custody to the father.
Correct.
So what do we do with the order?
I think the order remains, Your Honor, to some extent until someone files an application to modify it.
That's what I was going to ask. So if the order remains, then they're going to have to correct it on their own, correct?
Correct.
Okay, thank you.
Thank you.
Can you talk next quickly for
393 Schramm versus 9. Okay, we have everybody. You can proceed.
Good morning, Your Honors. May it please the court. Kristen McDermott on behalf of Mother Catherine. I think the strongest indicator that the family court's decision was really not based on the evidence was its finding that Joshua was the parent most likely to foster a relationship with the other parent. This is a person who took the two oldest children on what was supposed to be a 2-week vacation, got them down to Florida, and then said, the children live here now and I'm not bringing them back. And actually defied.
Did he offer to have the mother come there also?
He did. Both parties said that he asked the mother to move to Florida with him. But he was clear that she said no. At least eventually she said no, and she asked for her children to be returned. And
But wasn't that offer to, I'll help you move down here, after he took the kids under false pretenses all through the United States, went to West Virginia, Maryland, and all the way down to Florida? Then later, once he got down there and he'd already established himself, then he said, hey, you want to come down too? Right? Do I have it right? It wasn't like he said at the beginning, I'm going down to Florida, do you want to come? And she said no, and then he went to Florida. It was after, when they left, she thought they were going on a vacation to West Virginia coming back. That turned out to be anything but.
And he specifically said she was not welcome on this family vacation. She and the youngest child were not permitted to come. And then there was no discussion.
In addition, when the court's looking at the circumstances here and what's best for the children, there were some issues with the mother's situation. Her mother was a recovering crack addict, is that correct?
That's true.
And she's relying on her for childcare?
She was relying on her for financial support and some childcare. I don't think that there was ever really any explanation of anybody of why this grandmother posed any danger to the children, because she said if she ever relapsed again, she would just leave the home, and that's what she had done in the past. And I'd just like to point out,
Counsel, did she have the ability to leave the home? She was financially reliant upon her mother as well as relying on her for childcare. So how could we ever think she would have the ability to just leave the home?
Well, by the time of the hearing, Catherine did have a job. She had just gotten. And there were also other people in her life that she could have relied on for childcare and for help. She had her sister and her brother, and she had numerous members Joshua's family, who Joshua himself said, this is all my family in Syracuse who are there to help with the children.
Were there issues with respect to the children going to school with the mother before?
There were some issues with absences. I would point out that by the time—
Is it proper for the court to consider that?
Certainly the court could consider that, but I don't think it outweighed all the other indicators that Catherine would be the better caregiver. The absence situation really had improved a lot by the time of the hearing. After the kids got back from Florida, between January and the end of the school year, the oldest one had 3 absences that year. And even though the middle one had 11, it was indicative that she was telling the truth, that this was because he was sick. Because if it was just she couldn't wake up in the morning and get the kids on the bus, they both would have been absent. So, she said, yes, he was absent 11 times. I had to take him to the doctor, and that happens. And I think, even if the court takes this as a problem, it doesn't outweigh all the problems with the father, because he is not willing to foster a relationship with the other parent.
Right, look, this is how I look at it. If the father stayed in New York and hadn't left under false pretenses without telling her, and they had a dispute over custody, father wins, because there's all sorts of problems with the mother and the grandmother addicted to crack cocaine. As Justice Troutman pointed out, kids not going to school. If they're both in New York, father wins. What makes it a little more complicated is father's not in New York. He moves thousands of miles away without the mother's consent or knowledge. And it's not as though the father's mother is not without problems. She took the kids and kept them without permission, forcing her own son to sue her for custody. There's problems there, but it does seem like the father and his living arrangements is better for the kids than the mother and her living arrangements. But we have the problems. The father took the kids 2,000 miles away from the mother. And that can't be ignored. So it makes it a little closer case for me.
I think it's really important factor when you have one parent in Florida and one parent in New York, and they have to facilitate visitation twice a year. And so when you have one parent who does not think that court orders apply to him and he doesn't have to follow them, and one parent who's never violated a court order, I would just point out that in summer 2018, Catherine was ordered to send the children down to Florida, and she brought the kids to Vicky so that Vicky could drive them down to Florida, even though she unequivocally did not want the children to be with Vicky.
So are you arguing that the fact that she's shown a willingness to be cooperative with respect to visitation outweighs any other issues in her life?
I think it does that, and a couple other factors. I think the financial factor is really important. I think the fact that Joshua just left and was not supporting his kids for many, many months, I think is something that should have been held against him, and instead it was.
And her financial, are you saying her own financial circumstances are better than his?
There was no evidence that her financial circumstances were better than his, but I think a parent who's unwilling to support his children unless he has those children in his custody.
What I'm asking you, so there's evidence she herself was supporting the children? Is that what you're saying?
No, it was her mother, Eileen, who was providing the bulk of the financial support.
I think we have your argument on that. Thank you.
Okay. I just would like to point out this mother was always the primary caregiver of these children. She was the one who stayed home with them, and staying home with them made it so that she was less employable and she wasn't as able to, immediately get a job that she got a lot of money from. So, she was unemployed for a while, but it was because she had less earning capacity due to staying home and raising Joshua's children. And he was able to go out into the workforce for 10 years, get a lot of experience as a plumber, and then he, within 2 days of getting to Florida, got this great plumbing job. So I think that punishing her for that is incredibly unfair.
Thank you.
Thank you.
If it pleases the court, Rebecca Kantz for the respondent father. I'd just like to say—
What about the father taking the children?
I think it was a little bit of a mischaracterization. It was a planned family vacation. They had done it every year. This was the first year that the mother wasn't invited along, and it was simply because every other year she ends up self-isolating, and it made things awkward and uncomfortable on these family vacations. So this year
it was a family vacation to West Virginia. It was not a family.
It was a family vacation to a bunch of different places.
Florida? Did the father?
The mother was continuously informed where the children were going.
When the father left, the father left with the kid, did he say, when he left with the kids, did he say he was taking them to Florida?
I don't think at the beginning the plan was to go to Florida. I think that changed as they were traveling.
And then the family court ordered him to return the children from Florida because it was wrong. He waited 4.5 months before he finally got the 4.5 months. The family court tells him, bring those kids back here. He's down in Florida where he shouldn't be with the kids. 4.5 months it takes him.
His argument was that he was trying to get counsel and takes legal steps to remedy that, and he was afraid for the children's well-being if he returned them.
Right. So he ignored a court order, direct court order, because he, in his view, thought the children would be in danger if they came back. Correct. That's what you're telling me.
Correct.
Yeah, that's just that I have a real problem with.
I mean, they did eventually buy tickets and the children were returned. As far as the safety of the mother's home, she's been investigated by CPS for not picking the children up, not getting the children to school. The police officers had to pick the oldest child up from the bus stop and escort him home twice because she didn't go and get him. So he was standing at a bus stop all alone. There's concerns about Miss Anderson, who is the mother's mother, recovering crack addict, and that she's left responsible for the kids fairly often, getting the kids up in the morning and getting them fed. There was
statements that the kids are left to their own devices and they know to get up and get their own breakfast and get dressed and get ready for school because the mother is unable to get up.
So are you essentially arguing, regardless of how the children wound up in Florida, the overall circumstances with respect to the two homes is such that it is better for the children to be with the father?
Correct. They have a stable home environment. He has the support system of his mother, who has been a solid.
Whom he had to sue, whom he had to sue for custody, his mother.
Well, that was a situation where the mother had disappeared for months and he was left trying
With the
to
children,
work and
with
care
the
for three
kids.
kids, and he reached out to his mother for help. And he did have a discussion with his mother that was not appropriate, but they've gotten past it because he realized that his mother was taking that step for the best interest of the children. And when they got the children back, he forgave his mother because he realized that she was just acting. The children's mother had disappeared and the son was unable to care for them because he was working.
Thank you.
Good morning, may it please the court. I think the troubling issues that the record presents have been addressed by your honors and my colleagues. Ultimately, at the end of the day, as Justice Troutman pointed out, my clients are doing very well in Florida, and how they got there, that's one factor that the family court had to assess, and how much weight the family court put on that. I don't think the finding is against the weight of the evidence or an abuse of discretion. My clients' lives are generally more enriched by being down in Florida with their father and the paternal side of the family. They're involved in activities that, for one reason or another, they were not enrolled in while they were up here in Syracuse. There's a tutor involved. There's more people that are stable, and the employment situation of Mr. Nine has been stable. The self-serving testimony of the mother that now on the eve of trial, she's gained employment when this matter was pending for quite some time, I don't think is terribly credible. And relying on, unfortunately, her mother is a recovering crack addict. Kudos to her for being sober, but I don't feel comfortable with my clients being left in a situation where we have to trust that if the grandmother thinks she's going to slip, that she'll disappear and go off and then leave my clients to their own devices. So all in all, I think ultimately my clients' lives are more enriched, and it's in their best interest to be in Florida with their father.
Thank you to all of you. In the matter of Faith K. Thank you. I think we have everyone present. Please proceed.
Morning, please the court. Paul Watkins, appearing for the Cindy R., the mother in the case. I did brief all the issues, both in my main brief and my reply brief. The main issue I'd like to point out to the court is even the court agreed that my client was nonverbal. She could not communicate verbally, just nods and expressions. And yet, even the CPS worker who testified said he couldn't really know that she agreed or what she agreed to do about the alleged drug use. I made my other arguments. I think unless the court has some questions about those other arguments, I'll submit.
Thank you very much. Ms. Adams?
Thank you, Your Honor. May it please the court, Holly Adams on behalf of the Ontario County Department of Social Services. While appellant would have the court concentrate on the issue that his client did suffer a stroke and is nonverbal, that is not the main reason that this child was removed from her care and continues to be out of her care. It goes to a portion of the issues involved, her inability to care for the child on her own. But it is also important to note that she failed to follow through with any of the services for her children that she surrendered in 2015. The fact that she is somewhat nonverbal, there are other means of communicating with her, as demonstrated by the department, as demonstrated in the hospital records here. There was not a question of her capacity being problematic. And if the question of her nonverbal status was the main issue, I would have expected her attorney to have addressed it and taken care of it at the family court level. That didn't happen. There was nothing done to try and undo that conversation between she and caseworker Noon at the hospital. There were options available to her at the onset of this case, and they did not take advantage of that.
But in her answers in the hospital, the mother's answers, sometimes she nodded yes, sometimes she nodded no. It was not a consistent yes. She discerned different, she responded differently to different questions, indicating that she understood what was being asked. Otherwise, you would think her responses would all be consistent. Is that fair to say?
Your Honor, I think, oh, sorry. I'm sorry, were you finished?
No, I was finished, yep. I got nothing else here for you.
Oh, thank you. I believe, Judge, that is why the nurses in this situation asked her questions in different ways to make sure that they were covering the situation here. And also her communication came through the father of the baby as well.
Thank you.
Thank you.
Mr. Pulver?
Yes, Judge. May it please the court. I represent Jamie Kay, who is one of the respondent appellants. He's the father. The reason I think that the neglect doesn't hold is because the county has said that because the father didn't take certain DSS recommended programs, including mental health treatment, parenting classes, and to another extent, substance abuse treatment, though that's being contested. They don't really go and say why not taking these services makes it an imminent risk to the children, or just there's a big gap there, and that's all I'm saying. It's speculative, it's remote, and it's non-specific.
Thank you. Sky, you need to unmute.
Your Honor, I wasn't sure whether or not Ms. Adams was going to respond.
Oh, I'm sorry.
Other respondent.
I didn't give her a chance.
Thank you, Your Honor. I would just like a chance for a brief rebuttal. Mr. Krzyzewski doesn't get a pass for this child because he didn't complete services with regard to the other child. That was evidence to the department of his inability to care for his older child. At no time was that child ever returned to his care. That child was continually found to be remaining in foster care to be in that child's best interest. We don't now turn to another child and ignore all of that when we're right in the midst of that situation with the older child. As I said earlier, that's giving him a pass for not completing services that were necessary in order for him to regain custody. So in this situation, it was our belief that this child was not safe to return to his care.
Thank you. I'm sorry, I didn't mean to ignore you before.
That's okay, no problem. Thank you.
Ms. Gray?
Thank you. I represent Faith, and she has been placed in foster care essentially since birth. She is thriving in her foster care environment, and the foster family is an adoptive resource. And we also have adopted her half brother, who is Jamie Kay's child from the previous marriage. One point I would like to address is that for the mother, the argument has been made that her drug use and her answer to the question about cocaine use isn't relevant. And I certainly would argue that it is relevant to the care and treatment of my client, because the nursing staff and the doctors had to make an assessment of whether or not this child could be breastfed, since the mother had admitted to cocaine use shortly before the birth and tested positive, in fact, for that substance.
Thank you very much.
Your Honors.
Brian Trusick versus Liberty Mutual Insurance Group. There we go. We got everybody now, I think. Yes. Okay, go ahead, Mr. Schoonmaker.
Good morning, Your Honors, and may it please the court. I once heard argued before this court that there is a difference between thinking like a lawyer and thinking like a human being. I think that the struggle presented the issues in this appeal is it requires a bunch of lawyers to think like human beings about what theft is.
Okay, let me ask you this, Counselor. We have an undefined term in the insurance policy, correct?
Correct.
Okay, so when we have an undefined term, your position, as I understand it, is that we should give it its plain and ordinary meaning. Is that correct?
Yes, Your Honor.
And that if we give it its plain and ordinary meaning, even if we believe the facts as the plaintiff or the insured lays out, it doesn't constitute a theft.
That is our position. Yes, Your Honor.
Okay, so I'm going to let you proceed now. I just wanted to sort of get the, prop it up properly, but I know you were about to talk about that. So is there a difference with do you go to the dictionary, or do you just say, hey, what the average person going to get insurance would think or define the word theft?
The latter, I believe, would be the correct approach, Your Honor. I think this was addressed in the Van Vechting case it was a pretty old case, almost 100 years ago, but it spoke of theft not being a word that is susceptible to a single clear meaning under all circumstances, that really what the ordinary person would consider to be a theft is what is determinative of it. Our position is that the Supreme Court here applied an overly technical definition, essentially finding that because the definitions chosen by the courts did not include express language saying that a mistaken throwing away of objects is not a theft, that couldn't possibly be a reason to find that there was no theft. But I feel that that's similar to saying because the definition of cat doesn't say a dog isn't a cat, you have to assume that a dog could be a cat. Definitions are not technical in that manner. Perhaps they are in
What about this? If we believe what the plaintiff says, in other words, I didn't abandon the property, nor did I give permission, how does that affect your argument?
Well, Your Honor, I believe that goes to one of plaintiff's prose definitions of theft, which is that it is taking without consent. But I think the case law, particularly the case law addressing the definition of theft in the terms of insurance coverage, is clear that there needs to be some level of criminal intent or felonious intent, some level of intent beyond just merely the taking without consent before something can be considered a theft.
Now, why do you say that? Why do you say that? There needs to be some kind of felonious intent.
Certainly. Well, the definition, when I'm using the phrase criminal intent, when we're using the phrase criminal intent, felonious intent in the papers, we're merely referring to the distinguishing of some wrong that is not malicious and an intentional wrong. I think it's illustrated by the Kastner case from the Third Department. It uses the phrase, so it specifically says, in order for appellant to recover for theft under the terms of the insurance policy, she was required to establish a criminal intent to deprive the aunt permanently of the automobile. It then continues on later to say that because it was fairly inferable that the automobile was taken under.
We haven't said that though. We haven't said that really, have we? In the Fourth Department, there's the case, there's the Panburn case from a few years back, from 1999, and it seems what we do is we say, hey, look, in interpreting the provision, we give it the ordinary definition of theft. But then we don't go on to define theft. We just say it should be guided by, what an ordinary business person would think it is in making a contract. In other words, I think, as I understand that proposition, it's that I go and get insurance, and therefore, if you didn't define the term insurance company, it should be what, the ordinary person getting insurance thinks it means. So it seems that the definition you want to give today, pursuant to the third department, is a little more technical than this department has gone.
I wouldn't say that, actually, Your Honor, I wouldn't say that we're asking for this court to make a proclamation that theft always means this or doesn't mean this. But as with any case that's interpreting the ordinary meaning, and it certainly as recommended in the Van Vechten case, is that it is an evolving definition of theft. It depends on the facts of the case and the reasonable expectations of the parties. I think I tried to illustrate this in my reply. If you were eating at a restaurant.
So you're saying it's not a reasonable expectation that if someone takes something without my permission, that's not reasonable to believe that that is in fact a theft?
I think
it's depriving me of my interest.
I think that it depends on whether that taking was an honest mistake. And I think if you leave something in a place that someone honestly believes.
Applying that here.
Yes.
How does that support, how does your argument support that the court was wrong?
In this case, Your Honor, the home in question had already been essentially, for all intents and purposes, abandoned, with the exception of a few visits, apparently by the plaintiff, to collect objects that were there or to store objects there, as he claims.
But he says he didn't abandon it.
Yes, and I think the distinction there is whether, and this is sort of something touched on by plaintiff's argument and our response to that, is that there's a difference between a claim of right and an actual right. Geddes took possession and control of the property pursuant to the zombie property law, which actually required them to do so when they believed it to be vacant for 90 days.
Well, no, hold on a minute. It says that the bank, if the property is abandoned or vacant and so forth, the bank has to maintain and secure the property, the house, maintain and secure. It doesn't follow that a bank can go in and remove all the contents and throw them in dumpsters, which is what happened here. But I think I agree with your general point, if I just want to make sure you and I are on the same page.
Yeah.
What you're saying is that the negligent disposal of property under a mistaken claim of right, negligent disposal of property under a mistaken claim of right, that's what happened here. They thought they had the right to dispose of the stuff, but it turns out that they didn't. That is not theft to the ordinary person on the street. Theft implies stealing. Theft here, it was a mistake. It was negligence. That's not theft. So under your view, if we were to agree with you, it's not as though the homeowner has no remedy. It goes after the bank that made the mistake, if a mistake was taken. Now, there's a huge issue of fact of whether anything of value was removed there. It looks like, Mr. Bright says, we just took out garbage, trash, nothing of value. Plaintiff says he had hundreds of thousands of dollars there. That's an issue for trial. But under your interpretation, the homeowner still has a remedy against the wrongdoer, correct?
Correct, Your Honor.
If there is a wrongdoer, which is highly questionable.
Yes, Your Honor. I think that you touched on a key point here when you're talking about the not actually having a right. I think that it seems clear, at least from what I've been able to research, that the Geddes did not have the right to send a contractor in. It does appear that this was an honest mistake or a miscommunication between Geddes and the contractor. The cases in which that we cited in our brief, in which the courts have determined that there was no theft, despite the fact that there was a taking without consent, those are typically cases in which there was an honest mistake about who had ownership or possession or the right to take, not who actually had the right to go in and.
Right. For example, if we use the definition, if we say that the ordinary definition of any policyholder reasonable person on the street, is that theft is the taking of property without permission. That broad. Well, if you and I go to a restaurant, sit at different tables, and we have similar raincoats, green raincoats, after dinner, I take your raincoat by mistake. Would anyone in the world think that I stole your raincoat or that's a theft? Would anyone call me a thief?
I don't think so.
The answer is no. So it has to be more than the taking of property without permission, right?
Yes, and I think plaintiff acknowledges that by also arguing that it has to be the taking of property with the intent to permanently deprive the owner. I think that's the equivalent to what we're saying here, that there needs to be this criminal intent to deprive. I mean, that was the language in the third department case. They used those two terms in conjunction.
Well,
I don't think that was here either.
Counsel, I mean, there was intent to deprive here. They put the stuff in a dumpster. I mean, there was no mistake. They weren't going to bring it back to the restaurant in the prior example. There was an intent to deprive, but you're, I believe, urging us to add or to include some sort of criminal intent of some kind.
I think that even if this court requires an intent to deprive, it wasn't present.
But there was one. I mean, I don't know how you can argue. I mean, they permanently deprived these people of this, their belongings, no matter how valuable or invaluable you believe them to be, and they put them in a dumpster. So I think that aspect of the case is sort of a done deal.
If I may, Your Honor, respectfully say that from the way that I interpreted the record and the evidence that we see from TJMG, I believe that, and I know the Geddes brief goes into, well, these were objects of no value, and so that it wasn't a theft, and we don't agree with that position. We don't agree that the value of the items is a part of whether it was a theft or not, but that's a separate question, because I do think that the fact that TJMG and Geddes believed that it was garbage, that it was abandoned, that it was left over, that it was broken, indicates they did not have the intent to deprive the homeowner of this property. They didn't believe the homeowner possessed this property. They thought it was leftover garbage to be cleaned out. And if that was their subjective belief, then their intent wasn't to deprive him, even if that was the effect of their conduct. It was an incidental deprivation, not an intentional deprivation. And I think that's the distinction there.
Thank you.
Yeah, thank you, Your Honor.
Mr. Matthews?
May it please the court, I'm Dan Matthews. I represent Geddes Federal Savings and Loan. This was action done pursuant to 1308, the zombie property law, on behalf of Geddes. Once Geddes learned that the property was vacant, they were mandated to take certain steps, and that's secure, maintain, and
throw out. Does it secure, maintain? Does that also include throw out everything inside, including valuable furniture?
Well, Your Honor, we contend that there was nothing of value in the property.
Right, I understand, but I'm just saying from the plaintiff's point of view, hundreds of thousands of dollars stuff was thrown out. I find that highly dubious, but for our purposes, let's assume that that's the case.
Okay, Your Honor, this was not addressed in my brief, but 1308 7B requires a reading of the New York Property Maintenance Code, one of which section is 3081. That section mandates that the exterior of the property and premises and the interior of every structure shall be free from accumulation of rubbish and debris. It's our contention that the vendor, TCMG, removed rubbish and debris.
Right, I understand, and my guess is that that's what happened, but the allegations are that there was a lot of valuable non-rubbish, furniture, so forth, that was removed. If that's the case, then it's the bank made a mistake here in removing valuable property, correct? Because they didn't have permission, and they didn't. But if it went down the way the plaintiff said it did, the bank's actions weren't justified under Real Property Act law.
I would agree with that, yes.
Okay.
Anything further?
I have nothing. I just wanted to cite 13087B has to be read with Real Property Maintenance Code of New York, 3081.
Thank you.
May it please the court, I'm Andy Ryan and I represent the plaintiff in this case, Brian Prusik. There's no question that the property was taken from his home. The property was either taken by Geddes or some unknown party. If it was taken by some unknown party, Liberty Mutual doesn't dispute that it owes coverage here. The only time that there's an issue is if Geddes took the property. And that is the square issue for this appeal, as to whether or not, if Geddes took the property, whether there's coverage for this. Liberty Mutual's disclaimer of coverage here is based on this theory that if Geddes took the property, they took it under a mistaken claim of right. The problem with that is that Geddes has denied that it took the property. So Liberty Mutual is asking you to infer an intent that has not been displayed by Geddes. Geddes denies that it took the property. So if it denies that it took the property, it could not have taken it under a mistaken claim of right. Now, there's no question Geddes took stuff out of the house. I don't think that's an issue for this appeal. That's not the question here. The insurance policy covers theft. Okay, theft is an undefined policy term, but I am going to read the phrase for you. This is a quote from the policy. It says that it covers, and I quote, theft, including attempted theft and loss of property from a known place when it is likely that the property has been stolen. So when you have an ambiguous term, an undefined ambiguous term in an insurance policy, you have to interpret that in favor of the insurer.
Well, you missed a step, and I'm not suggesting that you're right or wrong saying it's ambiguous, but the first issue is it undefined? And we agree that it is, correct?
Correct.
Then the next issue with an undefined term is to determine whether there's a plain and ordinary understanding of it. And we do that by saying, is it understood by an ordinary person, or is it susceptible to two or more reasonable interpretations? If it's the latter, then it's ambiguous. And then you go to the principle of insurance law that says it should be construed in favor of your client. So we've got to get through the first step. Is theft it's undefined, and then the question is whether or not it's understood by an ordinary person.
Sure, and I'll address that, Justice Carney. And I think where there's the difference between the plaintiff and Liberty Mutual is on this felonious intent or criminal intent issue. I think we all agree that theft is the permanently taking someone's property without their possession. We just disagree as to whether or not felonious intent is required. The felonious intent that Liberty Mutual is claiming is required here, I laid this out in the brief, but it all dates back to this Van Vechten case. And the Van Vechten case is a Court of Appeals case from 100 years ago, where the mechanic took a car that he was fixing for a joyride. He intended to bring it back and give it to the owner when the owner came to get it the next morning. But unfortunately, he got in an accident while he was taking the car for a joyride. He was not stealing the car. The car was placed in his possession to fix it. And so what Justice Cardozo held in that case was that, look, this was not a theft in the ordinary sense of the term, because he wasn't trying to steal the car. He was borrowing it. Okay? So
but let me stop you right there.
Yeah.
That's an undefined term that's not ambiguous. That case is not an ambiguity case. Do you agree with that?
I agree with that.
Okay.
I agree with that.
And do you agree that they didn't take in that case, they didn't take a dictionary definition of that term? They just sort of took a common person's understanding of what that term meant.
And applied it to those facts, the facts of that case, correct.
So given if that's the principle law that we follow here, tell us how this constitutes a theft.
Sure. From the perspective of Brian Prusik, he walks into his house and his house has been emptied. Everything's been taken out of it. From his perspective, he doesn't care if it was taken by Geddes or it was taken by some other third party. someone stole his property. They intentionally took it with the intent to permanently deprive him of it. No one has come to Brian Prusick and said, hey, we took all your stuff and we put it in a storage locker, or we're holding this for ransom. They took the property, whoever it is took the property, has not returned it. It's now been 4 years. It's not coming back. He's not getting that property back.
Right, well, let me ask you this. Do you think if you ran this factual scenario by common people on the street, say, look, the bank asked the subcontractor to remove property from the house and throw it out. Do you think anyone on the street would say, yeah, that was a theft, that they stole anything? Or
I would say absolutely, especially given the fact that 3 months before, Brian Prusick sent an email to the bank and said, you do not have permission to enter into my property for any reason. That was clear. He notified them that because the bank had in March, 3 months prior, had changed the locks on his house.
No, I understand what you're saying, but most thefts, I think the average person would think theft and stealing is kind of similar. If you are involved in theft, you take something for yourself, for your benefit. You either drive it around, you keep it, you sell it, you do something. Taking it and moving it 20 feet and then throwing it in the garbage might not, to your average person, sound like theft. But to follow up on what you started with, there still might be a claim, because there's an issue of fact of whether somebody non-Geddes related came into the house and stole all this stuff, right? There's an issue of fact there.
Well, the judge held it was, I don't believe there is. The judge held that, and I haven't appealed that. So yes, there is a question of fact as to who took it. And
if it turns out that it wasn't, Geddes admitted they took stuff, that they say it was just junk. All the other stuff your client claims has been taken, these valuable things, if it turns out that it was stolen by somebody non-Geddes related, then your client has a valid claim under the theft, because it was actually stolen.
It's covered. Right? It's covered by the policy, and Liberty Mutual doesn't deny it.
And that's not before us.
That is not before you.
Gotcha. Okay.
Great.
Thank you.
Thank you.
Cassie Smith versus Daniel Cousins. Go ahead, Mr. Cantone.
Good morning. May it please the court. Peter Cantone on behalf of the appellant, Daniel Cousins. On this motion for summary judgment, the appellant clearly met his prima facie burden by submitting sworn admissible evidence that this plaintiff did not, as a matter of law, sustain a single one of the injuries that are alleged in her bill of particulars. In opposition, the plaintiff clearly failed to raise a tribal issue of fact for two main reasons. Number one, first and foremost, the plaintiff submitted no evidence in opposition.
That's not true. She certainly, she submitted the Santa Maria's, at first, I agree, it was unsigned and unsworn at first, but then it was corrected. It was a ministerial mistake and it got corrected.
Well, I would argue, Your Honor, that effort to correct that deficiency was an improper surreply and should not have been considered. In particular, I'll note that the court rules have recently specifically been changed to make that point clear that surreplies are not permitted.
But isn't it all irrelevant? The Santa Maria's affidavit mirrored his report. His report was submitted by you and your client, along with Langdon, because Langdon, he didn't rely on it. I agree, you keep saying he didn't rely on it. But the law talks about referencing. Langdon referenced Santa Maria's report. His report says the same things as the affirmation. So why don't we need to see whether what's in that report that you submitted raises issues of fact? Because if it does, you didn't meet your burden of proof, your initial burden of proof. And it seems like from what Mr. Steinberg argues is that Langdon says the plaintiff has average intellect, normal. She's normal, so she has no injury. The other expert, whose report is referenced by Langdon, a plaintiff expert, says she has low average intelligence, and that the exposure to lead, we know there was lead in the house. We know she was exposed to lead. We know her lead levels were 6 times what the limit should be. The only question is she one of these lucky people that had all those things for years, exposed to lead, had elevated lead levels, and somehow she didn't get any damage from it? That's the only real issue. But Santa Maria says, yes, she did. It reduced her intelligence level by 7 points. Isn't that a battle of the experts that was served up on a platter by the defendant?
Well, it was not, Your Honor. And the key thing here is that that is not what Dr. Santa Maria says in his report. And if you look at pages 138 to 139 of the record, Dr. Santa Maria goes through all of the things that he looks for when he is assessing a patient who's been exposed to lead, and he rejects every single one of them. He says, no, she does not have ADHD. No, she does not demonstrate hyperactivity, impulsivity, inattention. No deficiencies with respect to attention or processing speed. No specific learning disability.
But doesn't he say that she has a reduction in her IQ, which is associated with adverse impact on potential, work and et cetera?
Yeah, and a diminished capacity, which is certainly.
Yeah. Well, that opinion, right, is this formula that he uses to determine IQ loss is not based on actual evidence of injury. That standing alone is not evidence of injury. In other words,
you're trying to argue Parker versus Mobile?
Well, correct. But that opinion, and there's 2 cases in the first department that addressed this type of opinion, Adrian T. and Velos, which were cited in our papers. But basically, what his formula says is if a patient was exposed to lead to this degree, then
not just exposed, let's be clear, not just exposed, but poisoned. She had highly elevated lead levels during the years immediately following her stay in the defendant's property. Okay, it wasn't just exposed, like there was lead there and she was there. It was in her blood. Well, let's go ahead.
And the cases are clear that an elevated lead level is not in and of itself a diagnosis. It's a risk factor.
They're going to have to prove that at trial.
Right, and again, then
It's your burden now, though.
the battle of the experts issue.
Well, Dr. Santa Maria's opinion, his sole opinion is this formula, which all that it says is that a plaintiff exposed to lead to this degree can experience IQ loss.
Okay, so let me stop you right there. Okay, so under Parker versus Mobile, we know that statement to be true, right? In other words, the toxin is capable of causing particular injury, a general causation. And your argument is, as I understand it, the next level, the specific causation, as being exposed to sufficient amount to cause a particular injury, didn't take place here, and the affidavit by their expert didn't establish that it took place because it was conclusory and speculation.
That's correct, Justice Carney. And but the point is, it is not that formula, which may establish general causation that lead can cause injury, is not proof that this plaintiff did sustain an injury. And the only proof about this plaintiff from the plaintiff's expert is no, she did not sustain an injury. He goes through each of the diagnoses that he would consider and says no, she doesn't.
So it sounds like
caught up on. I get what you're saying. He walks through a number of things that didn't take place. She really didn't receive medical attention at the time, and it's it appears on its face to be a bridge too far. But is it enough with the statements that Justice Smith and I were talking about relative to the effects, and Justice Lindley, the effects on IQ, and getting back to, I think, Justice Lindley's initial point, is that enough to scratch the surface? It's a battle of the experts.
Well, I don't think it is, Your Honor. And if you look at the cases, the Hannah versus Lamfer case, which was decided by this court, where this court found a tribal issue of fact on this issue, there was an opinion from an expert on behalf of the plaintiff that the plaintiff suffered from a neurocognitive disorder. And there's nothing here.
I think we have.
Don't you think? I just want to make this point because I think you hit this hard in your brief. It sounds to me like what you're arguing is that her alleged low intelligence or moderate low intelligence, average low intelligence, whatever. There's so many other factors that could have caused it. Her mother smoked in utero when the child was in utero, and child was sexually abused, victim of racism, all these things. So that the plaintiff can't possibly link her IQ to the lead poisoning, correct? That seems to be your general tenor.
Well,
but the problem with that is they don't have to prove it. It's your motion. They have to prove that at trial. You have to prove on your motion, you have the initial burden of proving that she did not suffer any loss of intelligence or any other injuries as a result of the obvious exposure to lead paint. And just point out all these other possible causes. I'm not sure that's meeting your burden.
Well, Your Honor, the plaintiff's argument is that her IQ, whatever it is proof of an injury. Right. Her IQ here is not in and of itself an injury. It's just her IQ. It is what it is. It's not.
Yeah, in other words, getting back to the point I made with you is that even given this affidavit, you've established your burden, and there's no question of fact by their affidavit, it actually establishes your case because the only connection they make is with this lower IQ, and that is pure speculation and a conclusion. And it doesn't establish specific causation, and therefore you've met your burden.
That's correct. I mean, this theory that her IQ was diminished is based upon a simple.
Okay, wait a minute. You've said that repeatedly, and I think we understand that argument. And I think we're just going to have to look at this very carefully and see whether there are questions of fact here. Yeah, and I'm not trying to cut you off, except you've made that point repeatedly.
Well, the point I would just like to make is if that opinion is accepted as true, then all it would take is any plaintiff who has ever exposed to lead automatically has injury. You just fit it into their
you're exposed. Remember, again, as we have pointed out, we know that the level, it wasn't just like she'd been someplace where there was lead. It did affect her. It was in her blood. We know that. So it's different than a case where you say, there's chipping paint and this kid was in there but it didn't do anything.
Well, the case law is clear that it's not just the exposure that makes exposure to lead actionable, right? It's the development of symptoms, of injuries.
Right, do you think, let me just, and then we can wrap this up, but do you think the intelligence that the lead paint, one consequence of being exposed to high levels of lead in your blood is a lowering of your IQ? Do you agree with that or disagree with that? That's one symptom.
Well, I agree that's Dr. Santa Maria's position. That's.
But you're saying he's wrong on that's just that's not correct? Isn't that a common symptom that it affects your brain and your intelligence quotient?
Well, the problem, Your Honor, is Dr. Santa Maria's position is that is automatic. Irrespective of the evidence, you're guaranteed a loss of IQ. And first of all, I don't believe that that's supported. But second of all, that doesn't meet the standard for the plaintiff's prima facie case in a negligence case. It's not automatic injury.
This is not trial. This is not a trial. You got the burden. They don't have the burden here.
So again, this is a summary judgment motion. I think we understand your position, and we'll look at it very carefully.
Okay, thank you, Your Honor.
May it please the court, I'll try to present the plaintiff's position from the plaintiff's perspective. The Parker case which we all agree controls, deals with the fact that you're not going to find a smoking gun in a toxic tort case. You're not going to find little lead particles floating around in the blood. And while, of course, there must be injury, of course, there must be exposure, the next step is you have to show, as Parker says, that the plaintiff was exposed to sufficient levels of the toxin to cause the illness. And
specific causation.
That's the specific causation.
What illness do you have here? What illness, what injury are you alleging here?
Well, you've spoken about the IQ, but this is also on 138 of the record. Cassie demonstrated weakness in measures with strong demands on organization and problem solving. This is consistent with the research literature, which is supported that among individuals with a history of exposure to elevated levels of lead in early childhood, there exists elevated risk for weaknesses in areas including executive functioning / organization / problem solving. And there are a bunch of citations to the literature here. Dr. Santamaria, who, by the way, did not provide a formula, the formula he uses from paper whose lead author was somebody named Canfield. Dr. Santamaria was he did a lot of testing, and one of the telling things about his testing is that the specific deficits he found are specific deficits which the literature shows are typical of plumbism. This is a classic lead exposure case. This woman's lead levels when she was a toddler were through the roof. She has not only low IQ, 81% of the population has a higher IQ, but she has the very kinds of focused deficits.
Right. Now, Dr. Langdon seems to have a higher opinion of her intelligence. Let's just assume for the sake of argument that she has average IQ. Average IQ. She's right in the middle. You say she's in the bottom 19.
19%.
But let's assume she's had average. We know she was exposed to lead at very high levels. Isn't it possible that somebody with average IQ could still be injured? Meaning that if they hadn't been exposed, maybe they would have been much more intelligent. Their IQ would have been a lot higher. I mean, are we limiting plaintiffs in lead cases to those who are just at the bottom of the IQ range?
That's a very interesting question. I don't think that it really bears on this case, where we have not just the deficits of intelligence, but those specific cognitive problems.
Right, you have pointed out that there's and your papers have pointed out, and some court, that there is certainly other cognitive problems.
Yeah.
So you think there's questions of fact and
there are questions of fact, and this case is not similar to the ones that the defendant argued. In his reply, he says that this case is even less tenuous than Adrian T. But Adrian T, there was no lead exposure.
Right, and we were very well aware that there was lead exposure.
That case limped in here on one foot and did not survive.
I think we have your argument.
Well,
thank you.
Thank you.
Ronald Bradley versus New Penn Financial. Okay, go ahead.
All right, good morning. Eric Levine on behalf of the defendant appellant. The order granting summary judgment, canceling the mortgage lien in this case should be reversed, and summary judgment dismissing the complaint should be granted. Mr. Bradley's theory of the case is that his mortgage loan was accelerated in December 2009 when a prior foreclosure action commenced. That acceleration was never revoked, making his loan time barred as of December 2015. Mr. Bradley's complaint has been rendered meritless by the Court of Appeals' February 18th, 2021 decision in Freedom Mortgage Corporation versus Engel. In Engel, the Court of Appeals unequivocally held where the maturity of the debt has been validly accelerated by commencement of a foreclosure action, the note holder's voluntary withdrawal of that action revokes the election to accelerate, absent the note holder's contemporaneous statement to the contrary. In such a circumstance, the note holder's withdrawal of its only demand for immediate payment of the full outstanding debt made by the unequivocal overt act of filing a foreclosure complaint destroys the effect of the election.
Right, but in that case, factually is a little different. The withdrawal was in the statute of limitations there. Here it was without, it was beyond. Does that make a difference here?
No.
The timing of the withdrawal within 6 years or after 6 years?
No, it doesn't, because the rule that says the withdrawal has to be within 6 years was a pure creation of the appellate divisions, which was not adopted by the Court of Appeals.
Well, they were silent on it, right? They didn't they were agnostic, it never even came up.
Well, not necessarily. The Court of Appeals mentioned the rule exists. The Court of Appeals talked about how the appellate division had created that rule. But then when they came up with their own rule, they didn't include it. They said, accordingly, we conclude that where acceleration occurred by virtue of the filing of a complaint in a foreclosure action, the note holder's voluntary discontinuance of that action constitutes an affirmative act of revocation of that acceleration as a matter of law, absent an express contemporaneous statement to the contrary by the note holder. There are no conditions, there are no deadlines. That is what the Court of Appeals held.
But does it revive a statute of limitations that's already run?
Yes, because the statute of limitations runs from the acceleration of the loan. And if the acceleration of the loan is undone, then the statute of limitations doesn't run again until the loan is reaccelerated at some time in the future. The Court of Appeals could have put out a limitation on it. The Court of Appeals could have said, however, this only applies if the voluntary discontinuance is less than 6 years after the case is filed, but they didn't say that. And I know that the plaintiff respondent would like this court to add words to the Court of Appeals' decision that the judges themselves didn't see fit to include. But it seems to me that if the Court of Appeals, aware of the 6-year limitation, chose not to include it in their own holding.
So you're saying if they didn't speak to it, your client gets the benefit?
If they didn't speak, well, they did. The problem is they did speak to it. They mentioned the rule was adopted by the appellate divisions. And then when they crafted their holding, they disregarded it and didn't include it in their holding. So when we talk about, I'm not saying it's just silence. It's saying that the court talked about it. Then they talked. This is the holdings of the appellate divisions. Actually, it was unanimous. These are the appellate division requires deacceleration within 6 years. Here's our holding. No such requirement.
All right. So if you're right about that, then you win. If we're not persuaded by that, do you want to discuss your other argument, which actually your first argument in the brief on the Grover case in the third department? You want to get into that at all?
Yes, of course. So even assuming the court isn't persuaded that Engel doesn't require deacceleration within 6 years, this case, nevertheless, the statute of limitations in this case was reset when the borrower acknowledged the debt. In 2017, the borrower accepted 2 trial period plans. Both of those plans required him to acknowledge that his debt was still in effect.
Did he sign an acknowledgement?
Well, by physical bluing signature, no, but General Obligations Law, section 17-107 says a partial payment is sufficient to restart the limitations period.
Under circumstances that evince an intent for a promise to pay the remainder of the debt. So that's the problem I have here is the circumstances evincing the intent to pay the debt. Now, is there a difference between acknowledging a debt and promising to pay the balance of it? Is that one and the same?
I don't think the law recognizes the distinction, and they're both an acknowledgement. You can acknowledge a debt by written instrument, and that's 17-105, I believe, is what the respondent has put in their brief. But we're not talking about 17-105. We're talking about 17-107 that says acknowledgement by partial payment. And under circumstances here, this is those circumstances, because the Grover case, which is essentially exactly on point with near identical facts, had a situation where the borrower took the borrower accepted a trial period plan, made payments. Mr. Bradley here made no less than 6 payments.
Right, but one difference, Justice Trotman, I think, was referring to this. In Grover, the borrower signed a trial modification agreement, signed a document. Our guy, in this case, repeatedly refused to sign any modification agreement. Does that make a difference?
Well, we're talking about 2 different agreements. He refused to sign the permanent modification agreement that was offered to him after he completed the trial plan.
Did he sign the trial modification plan?
He signed it through his conduct, I would say. He signed
Right,
it.
again, but he didn't sign it. They did sign in Grover. We're not talking about a permanent modification in Grover. They signed a trial period modification there. Here, our guy didn't sign it, but you're saying, well, there were some conversations over the phone and then he sent the check in and that's the same thing.
No.
And maybe you're right, but factually it's different.
Well, here he also, if you look at the terms of the trial period plan that he accepted through his payments, it said that he was acknowledging the terms of his note and mortgage were still in full force and effect. That was the language in Grover that they said made it a acknowledgement. What else would that mean other than the borrower was agreeing the terms of his note were in full force and effect and he would comply with them. The terms of his loan, of which he was agreeing to comply with, require payment in full. There is no other way to look at this other than
we have cases from the second department that go the other way. This will eventually go to the Court of Appeals, but we got a split between the second and the third.
It looks like there might be a split between the second and the third, but the second department case that Dorson, that the respondent relies on, is a little different because in Dorson, there wasn't that language in the trial mod that said, I acknowledge the terms of my note and mortgage are in still force and effect, and I agree to comply with them. That was in existence in Dorson.
How about Genedy, though? How about the other second department case, Genedy?
I'm not aware if it was in that one either, but it was in Grover, and it's here. So what else could Mr. Bradley have meant when he agreed through his actions that all the terms of his current note and mortgage remain in full force and effect? He would agree to comply with the terms of a note and mortgage, which obviously include the obligation to make payment, made 6 payments under them. There is and never submitted any contrary affidavit in this case. There's no affidavit from Mr. Bradley in this record. He never denied any of this. There's no rational way to look at this other than he was making an unequivocal acknowledgement of his debt and intent to pay what he owed, because there was no other reason to be doing what he was doing other than that. And so he either, in this case, under Engel, the loan was deaccelerated when it was voluntarily discontinued because the Court of Appeals doesn't require it to be within 6 years. And in the alternative, this is a clear acknowledgement under Grover that is well-reasoned, has identical facts, and should be followed here.
Thank you. Go ahead, Ms. Williams.
Good morning, Your Honors. The first thing I'll say is that the Engel case really does not apply to this case. In Engel, the court acknowledged the fact that a mortgage foreclosure action accelerates the debt and starts the running of the statute of limitations. In Engel, the court also said that the statute of limitations expires 6 years after acceleration. And so if the court were to accept the appellant's reading of Engel, then the statute of limitations would not apply to foreclosure cases or not apply to this case, I don't know. It also renders CPLR 205 meaningless because CPLR 205 basically says if an action is timely commenced and then it is discontinued for any reason after the statute expires, that the plaintiff gets an additional 6 months. But if there is no statute of limitations in foreclosure actions, then CPLR 205 is rendered meaningless because a plaintiff could start an action and then discontinue it 10 years later and then restart it again. And so in Engel, the Court of Appeals spoke about, the strong public policy in favor of the statute.
Yeah, I guess it wouldn't be much different if we took the discontinuance of the action out of it and I sent a letter to accelerate, 6 years is come and gone, and then I retract or revoke that acceleration letter. That wouldn't start up the statute of limitations again, would it?
Well, it may, as one of the cases.
If it was outside the 6 years.
Well, it depends, because the letter accelerating the debt would start the statute running. If the statute expires after you either commence the action or send another letter, then that would not affect the fact that the statute has run, has expired. Right, because once the statute starts running, the clock starts ticking. If you send another letter 6 years or more than 6 years later, it does not change the fact that the statute is expired.
Yeah, okay.
The other thing that I'd like to mention is that, you know, as someone who has been doing foreclosure cases for a very, very long time, the one thing that I do know is that all HAMP trial plans and HAMP modifications have the same language, because the HAMP program it's the Making Home Affordable program. It's a program that was put in place by the Department of Treasury in order to prevent foreclosures, unnecessary foreclosures. So the language tracks. All the trial payments say the same thing. Although we do not have the Dorson trial payment plan, it is a trial payment plan that was offered under the HAMP program. And so I would assume that the language is the same because it is under the Home Affordable Modification Program.
Right, but don't you think counsel's right when he says your client, he made partial payments under this trial plan, and by making those payments, he acknowledged the debt. Why else would you pay the bank for a debt that you wouldn't acknowledge?
Okay, so the trial court cited to Schickel, I don't know, I'm sorry, I don't, Schickel, it's Crocker in the a third department case, the case that was cited by the trial court. The court said that, you know, partial payments may actually, you know, in fact, acknowledge the debt, but there is no unconditional promise to pay. Here, there is a implied promise to pay because there is a implied promise that future payments will be made if the parties can enter, or if the parties enter into a modification. Here, the condition was not met, and therefore the statute was not renewed.
So you can acknowledge a debt. You could make a payment and say, I hereby acknowledge all this money I owe you. But if you don't further say, and I promise to pay you like I'm supposed to, then that's no good.
I don't know if you literally have to say it, but what the Court of Appeals has held is that a partial payment may renew a debt if it is accompanied by an absolute and unqualified acknowledged by the debtor from which an implied promise to pay, from which a promise to pay the remainder may be implied. So here, all we have are alleged payments from the debtor. There is nothing else that the debtor sent to the appellant's predecessor in interest that would imply a promise to pay. Yes, you know, he made the payment because he wanted to enter into a affordable affordable modification. The other thing that makes this case not like Grover is that under the HAMP program, mortgagees are required to reduce the homeowner's payment to no more than 35% of their gross income. Here, that was not applicable. That did not happen. The HAMP program required the homeowner to sign the trial payment and send it in. What we have here is a unsolicited offer from a debt buyer saying, make these payments, and if you make these payments, you know, we will send you a loan modification. And so this is not like Grover. As a matter of fact, no case has followed the decision in Grover since Grover was decided in 2018. And so, you know, what we have here is an implied promise to make future payments, a promise that was conditioned on the ability of the parties to enter into an affordable loan modification. That condition was not met. And as the court in Dorson held, an express conditional promise cannot renew the statute. And so an implied conditional promise cannot restart the statute either.
Thank you.
Thank you, Your Honor.
In the matter of the Murad Revocable Trust, go ahead. Go ahead.
Good morning. My name is James Sonneborn from the firm Bousquet Holstein, and I appear on behalf of the estate. I want to simply make 2 or 3 very brief and I think important comments, because I know you've all read all the papers. First, I want to point out that the trustee was both an attorney, a sibling, and the trustee. I don't know that the law recognizes a duty higher than that of the fiduciary.
Counsel, here, there's no dispute that he was a non-domiciliary, correct?
There's no dispute that he was a non-domiciliary.
Whose conduct do we look to? Is it his or is it the decedent's conduct as to contacts with this state?
Well, I believe his conduct is dispositive of that issue, because for a period of years before she died, he engaged in a series of activities that impacted her, that were functionally in the state of New York. And
sending the checks? Are you referring to sending checks to New York?
Well, there is a series of things. He sent checks, he had communications, he made representations, he reneged on.
Was that based upon the fact that she removed herself to the state?
So, I thought about that, and had she removed herself or moved herself to New York State shortly before all of these problems, she moved in 2016. She died 4 years later. This is not a matter of her choosing to go to a state that's going to be favorable to her. She moved to New York State unrelated to the conduct that is before you for consideration. She was a resident of the state of New York. But
she made a choice. She made a choice as to where to live, correct?
She was not handcuffed and dragged into New York. She was smart.
So the point is, why is it fair under due process to say that the trustee is his conduct in responding to her because she's in New York is such that he should be brought into court here?
Well, the answer is, if she had moved to Wisconsin, perhaps Wisconsin would have jurisdiction. But she is the beneficiary, was in fact in New York, and his conduct then brought him to be subject to the jurisdiction of the courts of the state of New York. That is, the reality is that she lived here. The reality is that he engaged. I can speculate as to whether any of the things he did were really in good faith, other than sending some checks. But he engaged over a period of substantial time in taking action that impacted the beneficiary, who is now the deceased and who was a resident of the state for a period of approximately 4 years. So it's not a matter of forum shopping. She didn't move to New York because we have favorable laws. She didn't even move here because we have better judges. She moved here because this is where she wanted to live.
And so you're saying he shouldn't therefore be surprised that he would have to appear in the courts here?
Well, he's an attorney. He certainly shouldn't be surprised by that fact. He knew exactly what was going on, and his conduct, perhaps he's trying to thread the needle of doing something, but not being subject to the court. But the things that he did should have made him subject to the court. That really is the bottom line, is that he knew, as well as anyone could have, that the things he was doing were impacting her, that she was in New York, and that he was therefore accepting the jurisdiction of the court. That's really the point.
So you're arguing bestowing benefit to her by servicing the account and tending to her request, he subjected himself to jurisdiction of New York.
Well, I'm not willing to go so far as to say that it was benefit to her. He did do some things. He did send some checks, but most of the things he did were not for her benefit. They were to harm her. This record is really pretty appalling as to the things that he did. It's honestly not even clear that he ever established the trust corpus. But we've addressed the fact that we assume that there's a trust corpus, and that they did not raise the question with regard to jurisdiction over the corpus of the trust.
Thank you.
Thank you very much. Appreciate it.
Catherine Noga versus Brothers of Mercy Nursing and Rehabilitation Center. Okay. Go ahead, Mr. Getz.
Good afternoon, Your Honor, and may it please the court. My name is John Getz, and I represent Brothers of Mercy in this matter. And Your Honors, if I may, today I would like to start by discussing what we submit as both procedural and substantive errors at the trial court level with regards to, first, the sua sponte decision of the court below in reversing the original motion for summary judgment. And then, if you will, discussing this, ultimately this court's ability to correct that order and reinstate the original motion for summary judgment, which was granted in Brothers of Mercy's situation in March of 2020. And I understand that this can be a bit of a convoluted case as far as what happened over the last couple of months between, or 4 months, if you will, between March, or actually even February of 2020 into August of 2020. And the reason I use the word sua sponte, I think the record is clear that on March 16th, an order by the trial court was filed and then subsequently served on plaintiff's counsel.
As you know, we're aware of all the facts.
Yes, thank you, Your Honor. Okay.
And yeah, I guess the real curveball here is it appeared what the judge was doing was something sua sponte, and I know that's your argument, okay? But really, that letter that went out was from the law clerk, and it wasn't signed by the judge. So we wouldn't, if we were looking at this thing from a jurisdictional perspective, we would say it really has no effect. It's not an order and it's not an appealable paper. But then it looks like, really he did make his decision. He just was trying to change it, right?
That seems to be the issue, Your Honor, yes.
But then, I guess what he did was he sort of waited until, all the papers came in, and then he inked the order after consideration of the moving papers and the responding papers. And so if I was a betting man, I would say he probably made his decision when you say he sua sponte did, but the record really doesn't reflect that. I guess he waited. We don't really have a document from the judge until after he considered all papers.
And Your Honor, to your point, and I think that's a very good point, because I think the word curveball, as you said, as this court sees, there's many curveballs with what happened in this situation. I think where, Your Honor, you point out how we can suggest that the record is clear is the two causes of action which were ultimately stipulated to for discontinuance, and the fact that the court below, even though it had been briefed twice, had granted in total the reversal of its motion, its original judgment. In that first, Your Honor, the one cause of action we would submit, the record is clear, had there were missing parts to the cause of action with the wrongful death. And with regards to the other cause of action, the deprivation of dignity, I would suggest that that's a cause of action that does not exist in the state of New York. So the reason I would submit to Your Honor and to this court why we can reasonably infer the sua sponte portion of this is that even though there is no decision from the court, the order still kept those two causes of actions alive, even though there was really no basis in the record. And I hope that answers your question, Your Honor, because I've been really thinking through that as well over the course of the last 9 months, if you will. It is unique. And I think that leads us to the substantive issues here. And unless there's questions about the procedural issues, I'm happy to try to address those. But with regards to the substantive issues, we would submit that the original motion for summary judgment, which was granted, should be reinstated. And here's why. Mr. Noga was in Brothers of Mercy in his capacity as a hospice care facility. And the reason that's so important is, as this court sees and as the record is clear, there is multiple steps that go through with hospice care, including the fact that Mr. Noga is part and parcel to what should happen in the end of his days for life, for his life. And in this particular case, we have a situation where, sadly, Mr. Noga, who was a double amputee above the knee and had multiple health issues, obviously.
We know all that.
Exactly. He tried to get up out of his wheel. The record's clear. He tried to get up out of his wheelchair, and he fell. And it's telling that there's, again.
So there were a number of causes of action.
Yes,
and
Your
you're
Honor.
saying they should all go away.
Yes, Your Honor.
What about supervision?
Well, Your Honor, if you look, that's a very good point. There's nothing that shows that there was an issue of supervision with Mr. Noga. And in fact, he's in the day room.
What do you mean by that? Nothing shows.
Oh, excuse me. The record, I'll reverse it. Thank you, Your Honor. It's a good point. It's reversed. The record is clear. I would suggest that Mr. Noga is in a day room. It's heavily monitored. It's not a one-to-one facility, and I would suggest that's not the standard in New York.
When you say heavily monitored, I don't know what you mean by that either, because I think the proof showed us that he was alone when he fell.
He was for approximately 10 minutes.
Okay, so then heavily monitored, I don't know, to me, that sounds like multiple people were keeping an eye on him.
Well, and Your Honor, to your point, there's nothing that talks about having to have one-to-one ongoing observations of these individuals.
What do you mean there's nothing? You mean
There's
no plan?
There's no plan.
Okay.
There's no policies, if you will, to make that occur. And in this case, and when I say policies, New York State policies. And to the point here, what the plaintiff is relying upon is essentially Dr. Schwartz's affidavit or affirmation about a lap belt could have prevented his fall. Well, the problem we have with that, Your Honor, is first, we can't even assume that that's legal. There's policy, there's public policy.
But his testimony, I mean, what they say is that he said, I was going to get up. So he was going to get up.
Correct.
You know, but he somehow thought he had legs.
And
And
that's,
that probably goes somewhat to his mental capacity at that point in time.
at that point in time, it may, and I would suggest that there's nothing in the record of with regards to his medical documents that suggests that that's ever happened before. So to say that you need to put a lap belt on, which may, and that's the speculation, the speculative part, Your Honor, creates a real conundrum as to, yet again, who would be responsible for even making an order in having a lap belt put on this individual, assuming it could be done. And when I say assuming it could be done, what I mean by that, Your Honor, is, again, given his medical condition. That said, it would not have been Brothers of Mercy to make that decision. It would be Dr. Jacobus, his physician in this, Hospice Care Buffalo, and candidly, Mr. Noga himself. And we know that that's in the record, that he understood it's a no restraint facility.
That from the record that this is a no restraint facility. And in fact, his intention was to bypass that even if he could. He could have just reached over and removed the restraint. So why don't we go on past the belt to some of the other allegations?
Okay.
And I'll give you a couple.
Sure.
I'll try to help a little bit to give a little, structure. He was in declining mental health, wasn't he? I mean, I think the records show that he was, and yet he was left in a day room without supervision, on the day that he wound up falling out of his chair. He thought he could get up and walk. So let's talk about the supervision and the failure to have, the possible failure to have a updated instructions that deal with his declining mental health.
Well, Your Honor, first, with regards to the declining mental health issue, I would suggest to the court that when you look at the record, there really isn't much out there until that moment in time. And when I say much out there,
Let me ask you this, okay? He was on quite a bit of meds, wasn't he?
I'm sorry.
Medication.
Oh, yes.
And many of the medication had to do with his confusion. I'm just reading some notes from the record. His delirium, his agitation. He was on pretty strong medication on the haloperidol. So they knew he had some mental health issues. They were treating him for it. Okay, so even though this may be the first time that he tried to get up and walk, they were on some notice of his issues, mental health issues.
And Your Honor, to that point, that would then be the response to change any protocols in Mr. Noga's medical situation, in the determination of how to treat him medically. That would not come from Brothers of Mercy, but rather from, again, Dr. Jacobus and the Hospice Buffalo. And again, we're not saying that the doctor or hospice care did anything wrong either, but that's, to your point, Your Honor, who would be making those decisions. And so, and if you look
Not only decisions, but observations as well, you know, and wouldn't the Brothers of Mercy be in the position to make observations?
They would, Your Honor, and I would suggest, again, if you look at that moment in time on June 14th of 2016, Mr. Noga, without any issues, had lunch. He had just finished eating lunch, and he had asked, and then this is where I would submit that you have clear issues showing that he is capable of making his decisions, and that he asked to go, he eventually wanted to go down to the garden, but he asked to go into the day room to wait to go down in the garden and have some coffee. And that's uncontroverted, Your Honor.
Yeah.
And so that's my point, that, you know, you don't, especially in a hospice care situation, I'm not sure that there's really a time when you can make something where you're going to compel an individual to have a guard, if you will. There was nothing where Mr. Noga had indicated, I would like company, I would like to have somebody around. Again, the history that we have, keeping that context.
So it would have been up to him in your view?
I think it is. That's where he lived. That was where he chose for his end of days. That's what he wanted to do. And it is unfortunate. Nobody wanted to see him fall. If you look at the actions of the nurses, they did everything they can. They were on it quite quickly. And so I would suggest that when you, to your point, Judge, Your Honor, that's what we're breaking this down to, is that incident. So with all of the policy allegations that are out there, it still boils down to that point. That's what the plaintiff indicated was the problem. And I would submit that when you get to the issues of duty and causation, that they're not met at that point. The plaintiffs can't do it, because there's nothing that, just as I'm here and I have 5 justices and a court officer right by me, if I decide to do this, you can't stop me. No matter, unless you're literally, I would suggest, even if you're literally on top of that person.
I think we have that.
Okay. Thank you, Your Honor. And unless you have any questions, I thank the court.
Thank you.
Good afternoon, Your Honors. Nicole Marquez for the plaintiff. May it please the court. I think that the justices have had kind of hit this one with respect to the kind of procedural conundrums that we have had with respect to the order and the receipt of the letter from the law clerk. However, I think that the record really reflects that the March 16th order was entered and plaintiff properly noticed and papered a motion to re-argue, highlighting facts that the lower court appeared to have overlooked or misapprehended, and granting summary judgment to the defendants. After plaintiff fully submitted papers on the motion to re-argue, we did receive a letter from the judicial law clerk indicating that it may have been an error. However, that letter did not purport to stay the order granting summary judgment, to reverse it, or to have any impact on it.
And it wasn't signed by the judge.
Correct, Your Honor. You've noted an important fact there. It was a correspondence from the law clerk, and it was not accompanied by anything signed or written by the judge in this case. From plaintiff's perspective, I would submit that the defendants were provided an opportunity to oppose plaintiff's motion to re-argue, and that the court, based on the record and the order that was ultimately entered, granting re-argument and reversing summary judgment upon re-argument, reflects that the court did consider the March 16, 2020 order as law of the case, and then properly considered a motion to re-argue to correct
I
errors.
should get on to your next point.
Okay. So first, I just want to address some of the issues that Judge Bannister, you were asking the appellant about with respect to supervision. I think that the court is wise to point out that there was documentation that Mr. Noga was having reduced cognitive abilities. He had periods of confusion, agitation, delirium, and these are documented by Brothers of Mercy staff for days leading up to his fall. And I also want to address counsel's position, or the appellant's position, that there was nothing that required the staff at Brothers of Mercy to provide more supervision or monitoring to Mr. Noga in the over 2 hours that he was left alone in his day room. He did in fact have a care guide that required that staff of Brothers in Mercy provide redirection, reorientation as needed. There's no time frame on that. However, I would submit that if a resident with no legs is trying to get out of a chair, he could use some redirection or reorientation as to his physical ability to do so, so as to avoid injury. So I think that it's just factually inaccurate that there was nothing requiring them to provide him with supervision or monitoring because he was a hospice resident. I would also just like to address the lap belt. I think that plaintiff submitted facts and the trial court properly considered on re-argument that there is a battle of experts here with respect to whether that lap belt, in particular the kind that would be used at Brothers of Mercy, was even considered a restraint or that would be prohibited by the regulations as appellants maintain, and I believe their expert also opines to. However, I would submit that defendant's expert failed to review or consider testimony from Nurse Schaefer in this case, wherein she indicated that if she felt that a resident could benefit from a lap belt, she could just submit a work order to the maintenance department to put it on the chair. So that would not involve a call to Hospice Buffalo, but in any event, there's no indication that any work order was done to put that in place. And furthermore, plaintiff's expert, in opposition to summary judgment, did submit that the lap belt is not even a restraint under the regulations, in that it is a safety device that could easily be removed by the resident. And I would just also submit that that's not what we're dealing with here. I know that defense has argued that no one could have stopped him from trying to get out of the chair. However, there was no lap belt there, so we won't ever know if it would have stopped him, if it would have reminded him, drawn his attention down, and prevented this injury. And I would also like to mention that plaintiff has brought forth allegations related to the proper positioning of the resident in the tilt in space wheelchair from which he fell. The tilt in space wheelchair, as our expert opined, the purpose of it is to maintain the occupant in the chair and be tilted to such a position that they could be safely maintained in the chair and prevented from inadvertently falling out of it. Plaintiff specifically brought facts to the trial court's attention that may have been overlooked with respect to the fact that the care plan in this case, with respect to the tilt in space wheelchair, does only say slightly tilted. Plaintiff's expert opined that this was inadequate and left it to the subjective guess, essentially, of certified nursing aides and other staff at the facility with respect to how to properly place him in his chair. Though defendant's expert does opine that the facility took all proper precautions to prevent a fall for Mr. Noga, she says that that includes the slightly tilted wheelchair. However, she again did not review the testimony of the nurses involved in Mr. Noga's care, and Nurse Marshall.
So you're saying that based on all the facts and circumstances here, there are questions of fact?
Correct, Your Honor.
Thank you very much.
Thank you.
All right. Thank you.